Most drivers never expect it. The lights come on, the car pulls over, and what starts as a routine traffic stop turns into something entirely different the moment a federal badge appears in the window instead of a local officer's. Every day, across this country, people in that exact situation make one of 5 critical mistakes in the first 60 seconds. Not because they are guilty of anything. Not because they are reckless. But because no one ever told them what those mistakes are or why they matter. This video covers all 5. Backed by Supreme Court rulings, Fourth and Fifth Amendment protections, and real case outcomes. Whether someone is a citizen, a permanent resident, or undocumented, these rights apply. And they only work if they are invoked correctly. Stay through to the end. The 5th mistake is the one almost everyone makes, and it's the easiest to avoid once it is understood. This kind of information is one you shouldn't miss, so why not? Hit that subscribe button right now. Every day, I break down the legal rights that protect you and your family. You worked hard your whole life. You deserve to know the law that is on your side. Now let us begin. In 2023, a lifelong Arizona resident, born in the United States, a citizen for 38 years, was pulled over for a broken brake light outside Phoenix. The officer who approached was an ICE agent. The woman was polite. She answered the questions. She thought cooperation would resolve the stop quickly. It did not. Within 2 hours, she was at a federal detention facility. It took 4 days and a civil rights attorney to secure her release. Her record was clean. Her documentation was in order. Her only error was that she spoke when she had every right to remain silent, and she had no idea that right existed in that moment. That is the problem this video is designed to solve. Mistake number 1. Confirming or denying citizenship or birthplace. The situation. ICE stops a vehicle for a minor traffic infraction. Before the driver has processed what is happening, the agent begins asking biographical questions. Where the driver is from, where they were born, whether they are a U.S. citizen. The questions feel casual. Most people answer them without thinking. Why it happens. People assume those questions are harmless background information. They believe cooperation speeds up the process. They are wrong. Every biographical answer given at an IC stop becomes documented evidence. Immigration court has no robust exclusionary rule for statements obtained through aggressive questioning, meaning those words can be used in removal proceedings even when the original stop was questionable. Legal reality. The Fifth Amendment provides an absolute right against self-incrimination. That protection covers birthplace, citizenship status, and national origin questions, not just criminal confessions. ICE agents are trained to note accent, hesitation, inconsistencies, and body language as building blocks for reasonable suspicion. Body cameras capture everything. The footage is later used in immigration court. Silence alone is not enough protection. The Fifth Amendment must be explicitly invoked. The correct move. Invoking the Fifth Amendment right to remain silent. Declining to answer any questions about identity, birthplace, or immigration status. That invocation should be stated clearly and repeated calmly if agents continue pressing. Under Salinas v. Texas, explicit invocation is required. Once it is properly invoked, using silence as evidence against the speaker becomes a constitutional violation. Never volunteer citizenship information. In Stop and Identify states, providing a name may be required, but nothing beyond that. Birthplace is not required. Citizenship status is not required. Mistake number 2. Not separately invoking the right to counsel. The situation. A driver has invoked the Fifth Amendment. The agent acknowledges it and then pivots, asking about vehicle ownership, the purpose of the trip, or the passengers. The driver, believing the Fifth covers everything, continues to answer. It does not. Why it happens? Most people assume one constitutional invocation covers all subsequent questioning. It does not. The Fifth Amendment and the Sixth Amendment are separate protections. Each must be individually and explicitly invoked. Immigration enforcement is also classified as civil, not criminal, which means Miranda protections do not automatically apply, giving agents broader latitude to question without the standard criminal procedure warnings. Legal reality. Under Edwards v. Arizona, once the right to counsel is clearly and explicitly invoked, all questioning must stop. But ambiguous statements do not qualify. Vague expressions of wanting legal advice are insufficient. The invocation must be direct and unambiguous. Without it, agents can argue that subsequent answers were given voluntarily. The correct move. Invoking the Sixth Amendment right to counsel. Declining to answer any further questions until an attorney is present. Both the Fifth and Sixth Amendments should be invoked by name, separately. If agents claim they only need basic information, the invocation remains in effect. All questions are directed to the attorney. 2 amendments. 2 separate invocations. Both are required to create a complete legal shield against continued questioning at a traffic stop. Mistake number 3. Consenting to a vehicle search. The situation. After constitutional rights have been invoked, the agent shifts focus. A request is made to look inside the vehicle, framed as routine, standard, or a simple formality. The driver, wanting the stop to end, agrees. That agreement eliminates Fourth Amendment protection entirely. Why it happens? Consent feels like the fastest path out of a difficult situation. People also believe that if they have nothing illegal in the vehicle, the search cannot hurt them. That belief is incorrect. Entirely legal items, foreign passports, documents written in another language, money transfer receipts, letters with foreign addresses, can all be entered into an immigration file and used to build a case in removal proceedings. Legal reality. The Fourth Amendment requires a warrant for vehicle searches, with narrow exceptions. For interior traffic stops away from the border, ICE requires either consent, a judicial warrant, or documented probable cause combined with exigent circumstances. Consent removes all 3 of those requirements. Under United States v. Drayton, consent given during a traffic stop is legally valid even without Miranda warnings, which means the burden falls entirely on the driver to refuse. The search request is often a tactical move, not a procedural requirement. Phrasing it as routine, minimizing it as taking only a moment, or implying that refusal creates suspicion are all standard approaches used to secure voluntary consent. Refusal is not suspicious. It is a constitutional right. The correct move. Declining consent to any search. Asserting the Fourth Amendment right against unreasonable searches and seizures. No explanation is necessary. No argument is required. If the agent indicates a warrant will be sought, the appropriate response is to wait calmly. In the majority of cases, that warrant will not materialize because the probable cause needed to obtain one does not exist. Never consent to a search. Explicit refusal is the only way to preserve Fourth Amendment protection. Mistake number 4. providing information about passengers. The situation. Once the driver has invoked their rights, agents may redirect attention to the other occupants of the vehicle. Questions about who the passengers are, their relationship to the driver, where they are from, or whether they are citizens get directed at the driver rather than the passengers themselves. Answering those questions on another person's behalf creates a second set of evidence that neither the driver nor the passenger can later undo. Why it happens. Answering for passengers feels protective in the moment. Drivers want to manage the situation and keep it controlled. But every word spoken about a passenger becomes a documented statement that can be used to justify additional questioning, a separate detention, or an independent immigration check on that individual. Legal reality. Under Maryland v. Wilson, ICE agents may order passengers out of a vehicle during a lawful stop. But passengers retain fully independent constitutional rights, including the right to remain silent and the right to counsel. The driver's Fifth Amendment invocation covers only the driver's own statements. Speaking on behalf of a passenger waives nothing for the passenger, but it creates a documented record that agents will use. If any inconsistency exists between what the driver says about a passenger and what the passenger later says independently, that inconsistency becomes reasonable suspicion. The safest approach treats each individual in the vehicle as holding their own rights, which must be individually and separately invoked. The correct move. Invoking the Fifth Amendment right to remain silent regarding all other persons in the vehicle. Directing agents to address each passenger directly. Every passenger should independently invoke their own Fifth Amendment right to remain silent and their Sixth Amendment right to counsel. Those invocations are more powerful coming directly from each individual. Each person's rights belong to that person alone. Answering for passengers does not protect them. It only creates more material for agents to work with. Mistake number 5. Never asking whether the detention is lawful. The situation. The stop stretches on. Minutes pass. More agents arrive. The driver waits, assuming the situation will resolve on its own. The question that would clarify the legal status of everything happening, whether the person is actually being detained or is free to leave, is never asked. That silence is treated as voluntary cooperation. Why it happens. The moment feels too tense to push back. Asking whether the stop is lawful seems confrontational. People assume that if they were free to go, someone would say so. That assumption is wrong. Agents are under no obligation to volunteer information about a person's legal right to end the encounter. That question must come from the person being stopped. Legal reality. Under Rodriguez v. United States, a traffic stop cannot be extended beyond the time reasonably necessary to address the original violation without independent reasonable suspicion of criminal activity. Every minute of detention beyond that window requires documented legal justification. Without it, the extended detention may be unconstitutional, but only an attorney can challenge it later if the question was never raised at the time. Compliance without questioning the legal basis of a stop is routinely used to argue that the person was a willing participant. The longer the stop continues without challenge, the harder that argument becomes to overcome. The correct move. Asking clearly and directly whether this is a detention or whether leaving is permitted. If the answer is that the stop is a detention, the follow-up is to ask on what legal basis and what specific reasonable suspicion justifies it. If agents cannot articulate that clearly, the basis for the detention is legally vulnerable. If the answer is that leaving is permitted, the correct response is to leave, calmly and immediately. That single question is the most powerful one at any traffic stop. It forces agents to state the legal basis for the encounter on record. It cannot be asked too early or too often. Share this with every person in your household, every driver, every passenger. Make sure your family knows the difference between an administrative warrant and a judicial warrant. Knowing the law before you need it is the only thing that gives it power. Subscribe to this channel and hit the notification bell. Every video here is a breakdown of real rights and how to actually use them. More are coming on checkpoints, home visits, workplace enforcement, and more. This is the kind of knowledge that belongs to everyone.